Professor Scott Morton, before you have to leave, I wanted to talk to you a little bit about your.
I know.
He doesn't have the power to hold your
Apologize
plane.
again.
Yeah, I don't. In fact, you can get up and leave at any moment, and I'm not even allowed to. No subpoena. I'm not even allowed to take offense. So, in your testimony, you suggest that antitrust agencies, antitrust enforcement personnel within our antitrust agencies should commit themselves to evaluating the full range of potential competitive harms when investigating vertical mergers. Am I stating that accurately?
Yes.
Is there evidence you're pointing to suggesting that they haven't been, or that they've been willfully turning a blind eye with regard to indications of such harm?
There are a few examples we can point to where, yes, they've missed big problems. I would say in general, because there's this belief by some parties and by, I think, a lot of the courts that vertical mergers are fine, which again is not correct, leads the agencies to feel that it's a heavier lift. We saw that with the AT&T Time Warner litigation, the first litigation by the Justice Department in something like 40 years, I don't know, some very long amount of time, in a vertical merger, and the great skepticism by the court that anything could possibly go wrong with that. And that just isn't correct. So the example of Steve's Doors, Steve's and Sons, is the first litigated private merger challenge unwinding a vertical merger after the fact that was won by a customer, after the Justice Department was notified and failed to bring a case against it. So then the private parties took that after the Justice Department didn't, and they succeeded. So that's an example of a vertical case that was not brought by the government that was in fact proven to be anti-competitive after the fact.
And in that case, is it your view that they were aware of such information and willfully disregarded it?
Willful would not be the case. It's just, it's more that this is a high standard. You feel like you're going to lose. You don't have many resources. How do you devote those resources to best get the job done? If you think the court is hostile and you think there aren't merger guidelines you can rely on, then it's just a harder job, and then you're unable to protect consumers in that place. The people inside the agency, I will say it first came to the agency when I was the chief economist, and I do not remember hearing anything about this case. So whoever was analyzing it may have looked and not seen anything, or may have not wanted to look further because there were other more pressing things to do, or it may have trickled up eventually after me, and that decision was made as a matter of prosecutorial discretion. This would be hard to win, and the agencies wouldn't do anything about it. Or possibly the analysis was done incorrectly. I don't know, but all of these possibilities put together are just leading to a general under-enforcement level on this topic, just in combination.
Right, based on an inclination within the legal system in favor of such mergers.
Correct.
But it doesn't necessarily, you're not necessarily implying bad faith on the part of the regulators.
Oh, certainly not. No, not at all. I think we have a
failure to act. It's more just they're looking at it realistically from the standpoint of what they'll face in court.
Correct. The system is not supporting them. They would like to protect consumers, and the system is not letting them do that.
Okay. Thank you. Professor Garthwaite, Professor Greene suggests that CVS, Aetna, United Optum, and Cigna Express Scripts controlling so much of the nation's pharmaceutical spending itself suggests that we should expect to see higher prices as a result of vertical integration. What's your view on that?
Well, I think we've left a couple people out. So we've got Anthem, which is going to be creating its own PBM. It's going to be a series of blues. Then you have the blues in each state that are working with Prime Therapeutics. So you've got about 5 fairly big, and the states that they're in, the blues are really big where they are. So I don't think it's sort of self-refuting that this is going to end up raising prices. Where that threshold is about how many firms you need to get the competition, I think we don't have pure statement like two is enough, three is, but five seems to be a place where you're going to get some meaningful competition. Now the question is where they choose to play, right? You have like the three big nationals, and then you have the Blues. But even three, if you're able to pit a combined United, a combined CVS, and a combined Express Cigna against each other, that can be a pretty competitive contracting environment. I'd also note that if you are worried about this and you think there are these benefits from integration that people have talked about from United Optum, United Optum, if it's generating those benefits today, is keeping all of those as shareholder profits. And having people with a similar business model and a similar cost structure compete with them would discharge some of those benefits back to consumers.
Right. So in that respect, you're saying we should want more competition rather than less.
Yes, if you believe that this business model where we are in healthcare, given specialty medications, is you need an integrated pharmacy and medical benefit, you would like multiple firms to have that integrated pharmacy benefit competing with each other to drive down costs for consumers.
If you didn't have any more of those with that same capability, then that would increase the relative market power of those that remain, those who are already structured that way.
Correct, and what I'm saying is that you'll have anywhere from 3 to 5 depending upon the market, and that's pretty good competition.
Professor Greeny, what's your response to that?
So on the question of the pharma, the combined benefit of managing pharma and health services at the same time, that certainly is a possible benefit, and we don't want to rule those out. We have to quantify just how big that benefit is and how unlikely it is that it could be achieved by other means, whether insurance companies can get sufficient information from their PBMs and others about the trade-offs they have to make. And let me remind the committee, mergers often fail. In fact, there's some statistics that show 60–70% of mergers fail to achieve the promised shareholder value that they have promised their shareholders. So there are a lot of promises made, and mergers are undertaken with a lack of information between the two parties. You don't always know what you're buying, and culture clashes, lots of things occur that disrupt the efficiencies of mergers. So again, the argument is not that these don't occur, but they have to be carefully evaluated. And antitrust does a good job. It says efficiencies have to be verifiable. You have to show they are real. And secondly, they have to be merger specific. They have to be attributable to the merger and not achieved by other means. So I think what some people are saying is evaluate those carefully and weigh them against risks. And I think given some of the details of this, there is a question. Nobody knows what all the facts are because we didn't have a trial in that case.
Professor Garthwaite, did you want to respond to that?
I would just say that we do have pretty good economic evidence on these mergers that Professor Scott Morton cited. If we look at the difference between how a firm that operates a Medicare Advantage plan and how a firm that operates a Part D plan chooses to approach pharmaceuticals. And they really, if you're a Medicare Advantage plan where if someone gets sick, you're responsible for their hospital spending as well, you make different decisions about how you choose to cover drugs. So you're, at a very simplistic level, you're more likely to have low co-payments on something like a diabetes medication, so you don't get someone crashing into the ER because they're not taking their medication. And a Part D plan is less likely to do that. And so while I agree there are potentially contracts that we could write to do it, we haven't seen those emerge to date. What we have seen is that this exists when the firms are co-owned and is not emerging in a situation in which they're trying to do this with an arm's length relationship.
Thank you.
Well,
Dr. Capps?
sure. One of the impediments to writing a contract is that a lot of them look like I will pay you money to deliver less health care. And I think that's a problematic contract to tailor in a way that says only when it's efficient to deliver less health care, but not when it's healthy to deliver or harmful to deliver less health care. So contracts can actually be pretty tough, and that's one of the situations where we think vertical integration can sometimes be a good measure.